They're poisoning the blood of our country. They're not humans, they're animals. They're eating the dogs, they're eating the cats. These are, of course, words from our president directed at migrants, but we hear them in the CNMI too. Go back to where you came from. You don't belong here. Go home. As a Filipino and an American citizen, to me, these insults cut to my core because this is where I was born. This is where I was raised. This is where I belong. So if you ask me, birthright citizenship should be upheld because for me and thousands of others who were born here, this is home. To make this case, I will examine both sides of the topic, present a legal analysis of the topic, and discuss the underlying issues at the heart of the question before us today. To begin with my first point, let us examine both sides of this debate, starting with how birthright citizenship has been abused here in the CNMI. Specifically, it has been used to run the black market industry of birth tourism. According to data from the Commonwealth Healthcare Corporation, from 2008 through 2020, regular flights from China and visa-free access led to births from tourist mothers totaling 3,605, which represents more than 30% of all live births in the CNMI during that time. This has been so problematic that on the U.S. House Judiciary Subcommittee, Congressman Tom Tiffany, a Republican from Wisconsin, raised specific concerns about the CNMI. As he said, quote, "This is just one small example of how our immigration system has been used in so many different ways to be weaponized against the American people," end quote. At the national level, federal prosecutors in California recently reported, quote, "Birth tourism operations not only committed widespread immigration fraud and engaged in international money laundering, they also defrauded property owners when leasing the apartments and houses used in their birth tourism schemes," end quote. At the local level, birth tourism has strained our limited resources, our only hospital, our fledgling infrastructure, and our dwindling economy. All at a time when Chamorros and Carolinians are leaving the islands in record numbers, leaving those that stay as a minority in their ancestral homelands. So yes, birth tourism has been a problem, and we should explore practical solutions to fix it. However, despite this, we should continue upholding birthright citizenship because it is essential to the welfare of the CNMI for at least 3 reasons. Reason 1, based on recent census data, we can infer that about half of the population in the CNMI attained citizenship because they were born here. According to the 2020 US Census, from 50.7% of the population here were born after 1986, which is when birthright citizenship was legally authorized in the Commonwealth. While it's not clear how many of those were born here and how many of them are US citizens, the numbers clearly suggest that without birthright citizenship, about half of the population may not even be here. That would be devastating to our economy, our society, and our way of life. Reason 3, birthright citizenship has given thousands of students from the CNMI access to unparalleled educational opportunities. Unrestricted by foreign student visas, U.S. citizenship has given our high school graduates access to some of the world's top colleges and universities. U.S. citizenship has also qualified them for millions of dollars in federal financial aid. According to the U.S. Department of Education, from 2013 through 2018, college students from the CNMI were awarded a total of $19.9 million. If it weren't for their U.S. citizenship, they might have never been able to afford a college education. These are just 3 of the many reasons why we should continue upholding birthright citizenship in the CNMI. And while some may present legal arguments against it, I believe there is strong legal justification for it. This brings me to my second point. The 14th Amendment clearly establishes birthright citizenship under the legal principle of jus soli, or right of soil, where citizenship is granted based on where you were born, not based on the citizenship of your parents, which is the principle of jus sanguinis, or right of blood. To overturn the U.S. Supreme Court's 1857 ruling in Dred Scott v. Sanford, which denied Black American citizenship, the 14th Amendment clearly granted them citizenship, not based on their blood, but based on the fact that they were born in the United States and were therefore entitled to due process and equal protection under the law. Relying on where you were born, you soli, instead of who your parents were, you sanguines, ensured that race or ancestry would not be used to deny citizenship to anyone. However, since being upheld by the Supreme Court's 1898 ruling in United States versus Wong Kim Ark, some have questioned the necessity of birthright citizenship. They have argued that because the primary purpose of the 14th Amendment to fight racial discrimination has been fulfilled, we should revisit birthright citizenship. However, the persistence of systemic racism and other injustices tells us that this purpose has not been fulfilled. As the American Civil Liberties Union, or the ACLU, has argued, quote, in the current political climate, the 14th Amendment faces the realistic possibility of being stripped of its authority and its ability to stand as a bulwark against oppression, end quote. The ACLU thus declared, quote, it's imperative that we use every means at our disposal to assure that the amendment continues to serve as a path to freedom and full equality for those who need it most, end quote. This is especially important for jurisdictions like the CNMI. Even without Sections 303 and 501 of the Covenant, the 14th Amendment grants citizenship to people born in the United States and places, quote, subject to the jurisdiction thereof, end quote, which includes U.S. territories and commonwealths. However, the Supreme Court 2021 ruling in Fitusimanu versus United States could jeopardize that interpretation, which found that people born in American Samoa are not entitled to birthright citizenship. This ruling reinforces, more than ever, the need to maintain and uphold Sections 303 and 501 of the Covenant. But it's not enough to protect just these sections of the Covenant. We must do more to uphold the original intent of the Covenant, which brings me to my third and final point. When the CNMI's founding fathers secured birthright citizenship, it was part of a broader desire from the people of the islands to become a part of the United States. That's why the Covenant includes so many provisions that solidify this unique political union. Section 1's focus on our relationship to the United States. Section 7's focus on American financial assistance. Section 9's focus on collaboration with the federal government. And Section 3's focus on citizenship. And when an overwhelming majority of the people of the Northern Marianas voted to approve the covenant on June 17, 1975, they were voting for more than just a document. They were expressing their collective aspirations for a better way of life for them and for generations to come. That's what's at the heart of the covenant, and that's what's at the heart of today's debate. Something we all want for ourselves and for our families. A better way of life. This is what we all want for our home. And for me, I want a home where birthright citizenship is upheld, not just because it's good for society, or because it is supported by legal precedents, or because it's politically convenient. I want to uphold birthright citizenship because it has helped me and countless people like me call these islands home. And no matter what anyone says on 1600 Pennsylvania Avenue or on Beach Road, nothing can take that away from me. This is where I was born. This is where I was raised. This is where I belong. As the opening verse of the CNMI anthem so perfectly captures, Gitalo gihalom tasi na igaigi tanohu. Sa tilmatawal Pacifico, ia elo faluwe iye. In the middle of the sea is where my home is. Thank you.
Look around you. See the faces that reflect the beautiful melting pot of Saipan. I stand before you today not just as one of you, but as a living testament to the power and necessity of birthright citizenship. My story began here, on this very soil, under the vast, embracing arms of the Marianas. I am the daughter of 2 Korean immigrants, legal residents who, for 30 tireless years, poured their hearts and souls into building a stable life for me on this island they chose as their home. From my earliest memories, I was immersed in a vibrant mix of cultures. While my Korean heritage stood as a cornerstone, the Filipino, Chinese, Chamorro, and American influences that shaped my formative years significantly contribute to my identity. This rich cultural immersion led me to ponder the very essence of belonging. I understood my Korean heritage, the jus sanguinis, the right of blood, connecting me to my parents' homeland. Yet, I was born here. This soil, this air, shaped me. This is Usuli, the right of the soil, a principle enshrined in the 14th Amendment to the United States Constitution. That pivotal amendment, ratified in 1868, declared with resounding clarity, quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside." This wasn't just legal jargon. It was a profound statement about who belongs, about who is seen, about who is granted the fundamental rights and protections of this nation. The Supreme Court, in the landmark case of United States v. Wong Kim Ark, affirmed this ancient and fundamental rule. Birth within the territory, under the allegiance and protection of the country, grants citizenship, even to children born of resident aliens. For us in the Commonwealth of the Northern Marianas Islands, this right is doubly affirmed by the covenant that brought us into political union with the United States. Section 301 through 304 explicitly paved the way for American citizenship for those born here. Section 303 unequivocally states that all persons born in the Commonwealth on or after November 4, 1986, and subject to the jurisdiction of the United States will be citizens of the United States at birth. This isn't a privilege. It is a right, etched in law and in the very fabric of our being here. Yet, this foundational principle, the very bedrock of my American identity and that of so many others born here, are under debate. Elected officials are questioning whether birthright citizenship in the CNMI should continue or end. This isn't an abstract policy discussion. It strikes at the very hearts of who we are as a community and the future we envision for our children. So, does birthright citizenship help or harm the CNMI? For me, it was the key that unlocked a future filled with opportunity. It meant that the sacrifices my parents made weren't just for a better life, but for my full inclusion as an American citizen. It allowed me to pursue my education, to dream without the shadow of legal uncertainty, to contribute fully to the society that nurtured me. Birthright citizenship fosters a deep sense of belonging, weaving individuals into the social and civic fabrics of our islands. It empowers us to participate fully in our democracy, to contribute our unique talents to our economy. However, I understand the concerns that have been raised. The fear of straining our resources, the anxieties about demographic shifts. These are valid considerations that deserve thoughtful discussion. But we must not allow these concerns to overshadow the fundamental human rights at stake. We must find solutions that address these challenges without dismantling the very principle that ensures equality and belonging for those born here. What are the pros and cons? The pros are clear: integration, equal rights, economic contribution, and alignment with the foundational principles of American citizenship. The potential cons regarding resource strain and demographic shifts require careful management and planning, not the dismantling of a core right. Think about the impacts on our children, the future of our island. For them, for us, birthright citizenship is not a political concept. It is their reality. It means growing up knowing they're unequivocally American with the same hopes and opportunities as any other child born on American soil. To deny them this right would be to create a generation of second-class residents, individuals born and raised here like all others, yet denied the full promise of American citizenship. This would not only hinder their personal growth and potential, but would also fracture the unity of our community. Now, let's address the legal foundation. Even without Section 303 of the Covenant, would the 14th Amendment still apply? The consensus would be it would. The broad and inclusive language of the 14th Amendment, encompassing all persons born in the United States and subject to its jurisdiction, would likely extend to the CNMI as an American territory. Our covenant simply solidified that this application offered clarity and assurance. To question birthright citizenship here is to question the very applicability of the United States Constitution within our islands. This leads us to a profound historical understanding. The 14th Amendment rose from the ashes of slavery, a powerful tool to combat racial discrimination and ensure the citizenship and equal protection of formerly enslaved people. Its purpose was to eradicate the legal structures of inequality. And while we have made progress, to suggest that its purpose has been fully achieved would be to ignore the persistent realities of systemic inequality that continue to affect marginalized communities. The spirit of the 14th Amendment, its unwavering commitment to equality and the fundamental right of citizenship by birth, remains a vital cornerstone of American justice. To argue that birthright citizenship should end because its initial purpose was tied to the aftermath of slavery is to misunderstand its enduring significance. It has become a fundamental tenet of American identity, a testament to the ideal that birth on American soil makes you American regardless of your parents' origins. To dismantle it would be to take a step backwards, potentially creating new forms of discrimination and undermining the very principles of equality and inclusion that the 14th Amendment sought to establish. My own life, as a Korean American born on Saipan, is a direct result of birthright citizenship. It allowed me to bridge two worlds, to embrace my Korean heritage while fully participating as an American citizen, and it has enriched my life immeasurably. The debate surrounding birthright citizenship in the CNMI is not just about legal statutes. It is about people, about families, about the future of our home. It is about ensuring that every child born on our soil has the same opportunity to reach their potential as an American citizen. Let us not unravel the threads of belonging that make our community so strong. Let us uphold the principle of birthright citizenship, a principle that has made me and countless others born here unequivocally American. Let us choose a future of inclusion, opportunity, and unity for all who call these beautiful islands home. Thank you.
I am a product of birthright citizenship, alongside my older sister, who is now pursuing higher education at Eastern Washington University. Our country was built on the concept of the American dream, and many have immigrated to our great nation of the United States of America in pursuit of that dream. But what happens when we undermine this very concept by setting borders beyond our reach? Birthright citizenship is a beacon of hope for those who are seeking to live their American dream, or at least pass that opportunity down to their children. And isn't an opportunity to accomplish success a right afforded to us by our U.S. Constitution? I stand here before you today to discuss birthright citizenship, where my roots are. Decades ago, my parents, both from the Philippines, met on Rhoda as CW1 workers, dependent on their employment to stay here. They've been contributing to the economy and community. They built a home for themselves here and transitioned to having long-term residency, limiting them to only work and reside in the CNMI. Thanks to their sacrifices and this policy, my sister and I are upstanding U.S. citizens. The constitutional right of birthright citizenship made our American dream a reality. However, my story is not uncommon. Many from our community come from similar backgrounds. I can speak for many of them when I say that I am endlessly grateful for my parents, and especially for this right, for giving me a greater chance to thrive. To better comprehend what exactly is at stake, birthright citizenship is based on the principles of jus soli, Latin for right of soil, wherein citizenship is acquired by place of birth, regardless of their parents' citizenship. Jus sanguinis, Latin for right of blood, is the opposite, wherein a person's citizenship is determined by their parents' citizenship. Someone may gain U.S. citizenship through jus soli, like I have, or through jus sanguinis, or by being naturalized into the U.S. As a commonwealth under the United States, the CNMI has its own important legal backing for this right. Our CNMI covenant, specifically Section 303, guarantees U.S. citizenship under jus soli for individuals born in the CNMI. This section of our covenant mirrors one that is found in the U.S. Constitution. The 14th Amendment states, and I quote, "All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States." As a United States Commonwealth for nearly 50 years, the 14th Amendment would grant U.S. citizenship to those born in the CNMI, with or without Section 303 of our covenant. Birthright citizenship is not just a local right. It is a national, foundational, and constitutional guarantee. Although birthright citizenship is vital to immigrant families who have made the United States and the CNMI their home, there are concerns surrounding those who may abuse the opportunity. Birth tourism, or anchor babies, is a serious issue in the CNMI, where pregnant women come to give birth with the intent to secure U.S. citizenship for their child. According to Governor Arnold Palacios and the CNMI Health and Vital Statistics Office, birth tourism peaked in 2017 and 2018, with over 500 such births in each year. The concern of this societal issue in such a remote place like the CNMI is that we lack the financial means to support a quality and accessible health care for all. But could this issue be addressed by improvements in our immigration system, rather than a permanent change to a foundational right? Despite the systemic shortfalls that tempt people to take advantage of this policy, it has irrefutable benefits. It encourages people to settle in the CNMI and build families here, boosting our population, our contributing workforce, and strengthening our fragile economy. Recent threats to birthright citizenship has already caused a decline in our CNMI population. We receive federal funding for many of our programs, like education and healthcare, which are usually determined by our population size. Ending birthright citizenship would bring a devastating ripple effect that we just can't afford. The solution is not to abolish the right in its entirety, nor would it be to continue without addressing its flaws. We can confront the real issues of birth tourism and even temporary visa abuse through stronger policies. This includes stricter border security and stricter visa policies for temporary visitors, such as imposing limits on late-term pregnant tourists. Policies already enforced in the mainland, like consular officers denying a tourist if they believe they are traveling for birth tourism, must be applied here to ensure that only contributing long-time immigrants and local residents will be able to earn birthright citizenship for their child. Yet, under President Trump's administration, birthright citizenship came under national threat. Recent executive orders led to brutal realities. Children born in the United States to unauthorized immigrants, some even being too young to fend for themselves, were forced to separate from their families or be deported. Trump's previous administration's zero-tolerance policy separated 5,349 recorded children from their immigrant families in the span of 3 years. While this is aimed at undocumented immigrants, the potential expansion of this policy might someday affect long-term resident immigrants, and more so, their children, who have constitutionally earned citizenship. I witnessed firsthand the impacts of Trump's executive order that he calls, quote, protecting the meaning and value of American citizenship, when one of my classmates had his family's life uprooted with this initiative. Though he wasn't born here, he'd been living here since the 6th grade, and his younger siblings are U.S. citizens. Rather than face the risk of being forcibly deported or possibly having their family separated, they chose to leave on their own. Unfortunately, my classmate's story is not unique. Many immigrants who have made this land their home as contributing citizens were forced to abandon the homes they had built and start all over again in a motherland that they may have been so far removed from already. Their lives were upended, not because they disobeyed the law, but because the interpretation of their rights changed. It's even more important that we remember the original meaning behind jus soli. The 14th Amendment was originally passed to address racial discrimination by ensuring that formerly enslaved people and all born in the United States would be recognized as U.S. citizens. Some part of that initial goal has been achieved. However, its purpose is far from exhausted. There is more to be gained by our nation and our small island communities through birthright citizenship. In sustaining it, we can protect and provide for our people while standing up for equity and opportunity, values that our nation was built upon. In response to attacks on such a fundamental right, California Attorney General Rob Bonta challenged Trump's administrative efforts. He himself, a son of an immigrant, defended the rights of immigrant children, stating, quote, just because he's the president doesn't mean he can change the U.S. Constitution, unquote. He and other state attorney generals filed a multi-state lawsuit against Trump's efforts to rewrite the law. Like California, the CNMI relies on a dedicated immigrant workforce who deserve to see their hard work reflected in better futures for their children, just as my parents deserve. Let me be frank. Over 200 years ago, at the birth of our Constitution, our framers gave slave states 18 years to adjust their labor systems. There's no denying who our modern-day labor force relies on today: our immigrant population. It's 2025, and I'd think the people that make up such a valued resource in our nation deserved more than a 30-day deadline before their lives were forcefully changed forever. This begs the question: do we tighten our ship that is piloted by birthright citizenship, or do we ground it? Do we close the door on millions of immigrant families striving for their American dream with threats of deportation or worse? Or do we help them? What kind of future do we want for our people? The right decision can only be to honor a nation that has been built on the backs of our immigrant people, and to ensure that such a constitutional right as birthright citizenship is properly perpetuated by our nation's history, present, and future. Thank you.